Looks like people are still loading in.
You're good to go, Sarah.
All right. All right. Well, happy Monday. I am Sarah Pearson. I am the Executive Vice President with the Boca Chamber. And this subject that we're talking about today has probably been one of the most coveted subjects since this COVID-19 disaster has happened. We have heard from so many members as it relates to business interruption insurance. And so we're very thrilled to have very, very well-educated, seasoned, and well-known professionals speak to us about business interruption today. Before we get started, I'm going to ask Sophia to please get quickly on the phone, give us a few updates on, the recordings, how to use Zoom, and just a few housekeeping items. Sophia?
Hi, everyone. Good morning. Welcome to another Boca Chamber event. Just so everyone knows, we will be recording this entire presentation, so it'll be available on our YouTube playlist later this evening, and we will be sending a PDF of the slides to everyone afterwards, so please look out for that email with the link to the recording and the PowerPoint. We will also be taking questions. The team will be monitoring those questions and either texting the reply or verbalizing the answers. So to do that, if you go to the bottom of your Zoom screen, there's a toolbar. You click the Q&A icon, you'll be able to submit your questions that way. Thank you.
Thank you. All right, so it's my pleasure to introduce our speaker today. Marius Jed leads by example, providing every client with focused and helpful legal representation and services. For over a decade, Mr. Jed has been fighting for his clients by offering representation that is compassionate yet aggressive. He has successfully represented thousands of clients over the years, and if you've been in Boca Raton for any time at all, you know this gentleman. And so without further ado, I would like to bring Marius Jed up to the screen. Thank you.
Hi, folks. Good morning. My name is Marius Jed, and on behalf of Jed Lawyers, I'd like to thank the Boca Chamber, especially all the staff helping us out. Sarah, Sophia, Chastity have put together a wonderful program, as well as Troy. From our team on Jed Lawyers, I have assisting me here today, Scott Rosso. Scott is our head of our property damage division and has been practicing for over 15 years. And I also have on the phone or on this call as well as Nick Gadient, who is our director of marketing for the firm. As Sophia had mentioned, today's webinar is going to be very specific. It's going to be on business interruption losses from COVID-19. As we all sit here today, folks, we're all in unprecedented times. We're experiencing losses that we've never experienced before, and hopefully we can provide some education and answer some questions for you during this webinar. And I'm going to Sophia or Sarah, just give me a thumbs up if you see my screen.
We can see your screen.
Perfect. Okay. And again, at the end of this presentation, we're going to share this presentation so everyone can review it and have some further questions answered if necessary. During this webinar today, folks, we're going to cover some different topics. This is not an exhaustive list, but this is some of the topics we're going to cover. We're going to look at some specific policies and how they provide coverage for you during these types of business losses. We're also going to cover some legislative and executive efforts and how different states are reacting to the COVID-19. We're specifically going to look at exclusions and how those exclusions may apply. We're going to look at some litigation strategies, and Scott Rosso is going to talk about some of the litigation strategies that we're employing to help our clients. We're going to talk about damages and how those damages may relate to your policy. And then we're going to talk to you specifically about protecting and pursuing potentially bad faith claims for your losses due to COVID-19. But before we get into the technical components, obviously you all know Jed Lawyers has been in town for a long time, and we are a multi-service practice. We have really three main practice areas within the firm. Our first practice area, which we're discussing today, is our property damage division, which covers these types of losses. We also, in that division, handle your typical water leak cases, fire cases. We handle tons of hurricane cases in that division. And then within that division as well is this specific niche of business interruption, which is covered under your property policy. Additionally, we have a bodily injury division, and within that bodily injury division, we cover auto accident, motor vehicle accidents, wrongful death cases, slip and fall cases, or cases where you suffered an injury as a result of someone else's wrongdoing. And then thirdly is our PIP revenue collection division. And within that division, we represent medical providers, hospitals, and healthcare providers, and we help them protect their bill. When someone in Florida is injured in an auto accident, their PIP coverage is their primary coverage. And the doctors, via a assignment of benefits, bill the insurance company, and the insurance company is supposed to pay the doctor for those claims. We represent the healthcare providers in that situation to make sure they get paid properly. So now I want to get into this. I want to get kind of technical here. And in research of this presentation, I found some interesting statistics that I wanted to share with the audience. In 2018, the insurance industry wrote $1.22 trillion in premiums. That means they collected over $1.22 trillion in revenue. Similarly, in 2018, there was $1.7 trillion in property and casualty cash and invested assets. That is money that they had on their balance sheets to pay for these types of losses. And I found this statistic very interesting. In 2018, there were $49.5 billion of claims paid out. You folks can see the simple math here. The premiums are twice or three times as much as the claims that they've paid out. And that's for a statistic of 2018, so it's pretty relevant. Diving right into the policy. So just a little bit of background about insurance policies and kind of where this coverage lies. Most businesses are familiar with what we call general liability. And a general liability policy covers you and your company in the event that someone else sues you for a third-party loss. So the simple example is you own a restaurant, you own an office building, you own a business in town, and you have people come to your business. They come to your lobby and, God forbid, someone slips and falls and gets injured. In that policy, general liability, your organization will be covered for damages sustained as a result of that third party's injury. Here, we're talking today about business interruption policies. Business interruption policies are generally part of your property coverage form. And your commercial property coverage form could be the situation of a tenant, or it could be the situation of that you're an owner occupant of the building. There are many other types of insurance, such as malpractice, errors and omission, third-party coverages. Specifically, there's a policy for pandemics, which, if anyone has recently reviewed the Wimbledon case, where Wimbledon actually bought a specific policy to cover, in the event of a pandemic, a standalone policy, which would cover for their business losses. They purchased that policy, and the insurance company paid that claim already, because as we know, Wimbledon didn't happen. Here, the policy we're talking about that most likely your coverage for business interruption would be afforded is your commercial property coverage. So we get a lot of questions, and our firm will look at all these policies for you and review them at no charge, but that's generally when we're looking for. It's under the commercial policy. As you can see on the screen, I have an endorsement here, which is labeled the Business Income and Extra Expense Coverage Form. As you may know, your property coverage, the main perils of a property coverage, cover you against physical damage to your property. And I'm going to use a very simple example. You have an office building on Federal Highway, a tree falls down on your roof and crushes your building. Your property coverage will pay for loss or damage as a result of that insured loss, i.e. the tree falling on the roof. And the insurance company, pursuant to the policy or the contract between you two, will put you back to where you were prior to the loss. meaning they have to pay for the damage to the roof or any ensuing loss that may occur, such as water damage in the property. So within that commercial property coverage, there's this nuance of business income. And generally, most commercial property coverages include this coverage, but you have to make sure you speak to your agent and your agent understands your business and understands the risk that you may have. So it's always important, and we work with a lot of agents, and sometimes they come to us and ask us questions, and we're more than happy to provide questions and answers to them. But when you're dealing or trying to procure your insurance, most times you're going to be dealing with an agent, and it's always important to make sure that the policy that agent is writing for you starts with what we call an all-risk policy. And an all-risk policy, as it means, covers all the risks. And then later on in the policy will have different endorsements or different amendments which either add coverage or take away coverage. So we always advise our clients, you want to start with an all-risk coverage and then move forward from there. And again, specifically in this region, you want to add business interruption. And many reasons why you want to add business interruption. Just common sense here. You want to protect your business assets in the event that you can't perform your business. In South Florida, we're mainly hit with hurricanes on an annual or semi-annual basis more frequently than other states. So if you operate a business in South Florida, just because of hurricanes, I would extremely advise people to have business income coverage and make sure they tell their agents to add that in. Now that we're in this pandemic, which none of us have ever been through before, going forward, I would make sure that everyone includes business interruption or business income coverage to properly protect their business and the assets of the business. As you can see, the screen here has a slide, which I hope everyone can identify where it's blocked out in red. I'm going to read this specifically from the endorsement itself. This is the business income and extra expense coverage form. And this specifically states, coverage A, business income. Business income means the A, net income, net profit or loss before income taxes that would have been earned or incurred, and continuing normal operating expenses incurred, including payroll. So that's what the coverage is providing for you. The insurance company has collected a premium and they're giving you this endorsement, and they're making a promise to you that they're going to pay for the net income and the continuing normal operating expenses incurred, including your payroll. So this is the type of endorsement and coverage that you want to include, and you want to make sure that your agent knows to properly include that in your policy. Moving forward. Right now, or actually today is the first day we're coming out of this civil authority, but there's this concept called civil authority, which again is an endorsement provided to the policy, and this would be additional coverages that are important for you to make sure you speak to your agent or your insurance company to make sure this is included. And the common policy verbiage of civil authority is an action of civil authority that prohibits access to the described premises due to direct physical loss or damage to the property other than at the described premises. And specifically, if you read the endorsement where I've highlighted it in red, beginning with number 3, we will not pay for loss or damage caused by or resulting from any of the following, and this is the most important word, but if loss or damage by a covered cause of loss results, we will pay for that resulting loss or damage. That's the triggering part of the coverage. I'm going to read it again. But if loss or damage by a covered cause of loss results, we will pay for that resulting loss or damage. And then if you go down to B, acts 3B, acts or decisions. Acts or decisions including the failure to act or decide of any person, group, or organization or government body. So folks, I would submit to you today since March 13th, the state of Florida, according to Governor DeSantis, has issued numerous executive orders closing down each county, and each county has additionally issued multiple executive orders requiring businesses to close down. And that's the reason for the loss right here, folks. But for Governor DeSantis, or but for the different mayors and city officials issuing these executive orders, everyone would be at work most likely, and there would be no need to look at our policies, and there would be no civil authority coverage. However, here, since specifically we have all these executive orders, there is a clear and convincing civil authority argument. However, interestingly enough, the state of Florida has, and around the country, by the way, has taken a tiered approach, is what I'm calling it. They're having a phase 1, a phase 2, and a phase 3. So as we know, today is the first day for Broward and parts of Miami-Dade to reopen. Last week, Palm Beach opened. So we're in what we call phase 1 right now. And what does that mean? That means restaurants can operate at 20%. In Palm Beach, I saw today on Instagram of one of my friends that gyms are reopening, which is absolutely crazy to me. Restaurants again are operating at 25%. Barbershops are back open in a limited capacity. Nail salons, hair salons are opening at a limited capacity. So when this happens in this tiered approach, whether it's 25% or 50%, there's still an argument that there's a civil authority coverage here, because the government or these executive orders are still restricting how you can run your business, and they're still restricting the amount of people in your building or the amount of restaurants or patrons in your business. So I would continue to argue that civil authority coverage will apply until we have a fully open economy. When that happens, I don't know. Okay. So this is, moving forward, I want to talk about some exclusions. And we are reviewing hundreds of policies for our clients and potential clients, and we see an array of different things. And I'm going to highlight some of the exclusions that we're seeing, and I'm going to highlight some of the issues that we're spotting within these policies. The first thing that I want to point out here is this exclusion that's highlighted on your screen right now is called the exclusion of loss due to virus or bacteria. And it's important to understand that, again, that this is a contract between you, a business owner, and the insurance company. And it's a benefit that you bargain for with the insurance company. And that means you pay them a premium, and they make certain promises to you to cover these types of losses. But it's important to understand the genesis of specifically this endorsement and where this came from. As I mentioned before, there's an organization called ISO, Insurance Service Organization. ISO is an entity that puts together policy language and policy endorsements and policy amendments. It's like a bank of insurance policies, a document bank of insurance policies. Certain insurance companies use ISO forms so there's continuity in coverage. So for example, Lloyd's may use an ISO form. State Farm may use an ISO form. Progressive may use an ISO form. And the reason they do that is there's continuity and formality of the policies, and people understand what they mean and how they're interpreted. Back in 2003, if you recall, we had the SARS incident. And as a result of SARS, specifically, this endorsement came out and started breathing a life of its own. So there was the SARS epidemic happened in 2003. Obviously not nearly close to what we're experiencing now. And in that period of time, the ISO organization came up with this limited fungi, bacteria, or virus coverage. And again, they were intending to specifically relate this to the SARS virus. However, this endorsement does not preclude other viruses potentially. So again, what we tell our clients and potential clients is, you need to have us look at your policy. It is extremely important for us to review that policy to see how the different endorsements may come into effect and how the different coverages provided may come into effect. I want to read another endorsement to you. That is the exclusion of loss due to virus or bacteria. We are seeing this endorsement, and although we're seeing this endorsement, we're still telling our clients to send us the policy, and we still are retaining clients that may have this policy endorsement if there are other certain provisions within the policy. You know, clearly this endorsement came after SARS and came after the different H1N and swine flu. So this is, to me, something that's a little more on point, and I'm going to read it specifically so you can see it. This is an exclusion of loss due to virus or bacteria. The exclusion set forth in paragraph B applies to all coverage under all forms and endorsements that compromise this coverage part or policy, including but not limited to forms of endorsements that cover property damage to buildings or personal property, and forms of endorsements that cover business income, extra expense, or action of civil authority. We will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganisms that induce or is capable of inducing physical distress, illness, or disease. However, this exclusion does not apply to loss or damage caused by or resulting from fungus, wet rot, or dry rot. Such loss or damage is addressed in a separate exclusion in this coverage part or policies. The reason I'm highlighting this, folks, for you is that, as you just heard me read, this is very confusing. This is one page of a 180-page policy, and you really need to read the policy in its totality. You need to understand how this interrelates with other provisions within the policy, and you need to understand how the concurrent causation may affect this endorsement. And I'll describe concurrent causation a little later on. So although this policy appears to be directly on point, there may be other policy provisions which keep you, which provide you coverage. And again, we are still reviewing these policies every day, and a lot of these policies, folks, do not have this exclusion. Specifically, we are seeing it in certain industries, which I'll talk about, but the good majority of policies that I'm reviewing and our team is reviewing do not include this specific endorsement. Interesting. Another endorsement that we see on a limited basis is called the communicable disease exclusion. And this is a provision that says the following exclusion is added to paragraph 2 exclusions of section 1, coverage A, bodily injury and property damage liability. A, this exclusions. This insurance does not apply to communicable disease, bodily injury, or property damage arising out of the actual or alleged transmission of a communicable disease. And folks, the trigger of coverage, as I mentioned before, is in our policy is direct physical loss. And the direct physical loss is a result of the executive order that you cannot use your building. We are not arguing property damage, and that was the example of the tree falling on the roof, and we are not arguing bodily injury. We are arguing direct physical loss as a result of the civil authority and as a result of these executive orders have prevented you from operating your business, therefore causing you a loss, which may be covered under the business interruption endorsement. Another endorsement we commonly see, silica or silica-related dust exclusion. And again, just reading the language here, the following exclusion is added to paragraph 2, exclusions of section 1, coverage A, bodily injury and property damage. Exclusion. And I'm going to focus here specifically on the property damage part. This exclusion does not apply to property damage arising in whole or in part out of the actual alleged threatened or suspended contact with exposure to existence of, presence of silica or silica-related dust. Folks, again, our trigger of coverage is direct physical loss. We are not arguing property damage. As you can see from the endorsements that I pointed out here, that most of these endorsements are relating to property damage, and that's the example of the tree falling on the roof. Here, the case is a lot different. Going to move on now. So as in any case with an insurance contract, there are certain conditions precedent that you must comply with. And those are generally called the duty to mitigate. And I'm going to use an example of a property damage, and I'm going to use an example of the tree falling on the roof, or the tree falling on the roof. In that example, you have a duty to mitigate, to protect your property, to protect it from further damage which may result from that tree falling on the roof. Now, if it's feasible, the common duty to mitigate in that example would be to put a tarp on the roof. Now, that doesn't mean you have to get on the roof to put a tarp on the roof. That means you need to make reasonable expectations to try to hire someone to put a tarp on your roof to prevent the property from being damaged further. Here, we're talking about protecting your property from a direct physical loss. And how can you do that, and how can you mitigate your losses as it results to COVID? First of all, the most common thing is social distancing. You want to keep your people, if you're bringing your people back, at a minimum of six feet apart. We're hearing many, just this weekend, if you drove around the Ave, or you went to Meisner, or you went to some other places in Delray, there are people, and they seem to be congregating, and quite frankly, in my opinion, not practicing proper social distancing. So that's an example of a duty to mitigate. Also, making sure people that work, employees that work for your organization, wear masks in the office when and if you bring them back. Additionally, making sure your customers that walk in your organization or walk in your building or your premise wear masks. Again, making sure you have cleaning crews, deep cleaning your surfaces to make sure all the handles, all the highly traveled surfaces, the copy machines, all of that is cleaned on a daily basis with the proper materials and proper cleaning agents. That's something that we believe is one of the ways you can properly protect your property and also satisfy your duty to mitigate your losses. Civil authority coverage, as I mentioned to you before, everything we're talking here, folks, is so policy specific. Everyone that we talk to, we request a certified copy of the policy. And what does that mean? Most people, when they get their policy, their agent or the insurance company sends them the policy, and that's, like I said, a 180-page policy. Once that policy is renewed, the company doesn't send you a whole new policy, they send you a renewal deck page. And as the years go on, you may have renewed that policy for multiple years. So when we're retained, the first thing we do is request from the insurance carrier a certified copy of the policy. And what that means is the insurance company sends you the policy with an affidavit saying this is a true and accurate policy under penalty of perjury, that this is the accurate policy that's in effect at the time of loss. And that is so important because as years go on, as I described before, endorsements are changing. ISO is making new endorsements. Coverage could be expanding. Coverage could be contracting. So you need to look at your specific policy and the complete policy and review it all. And we're seeing on certain policies, there are limitations. For example, civil authority may have a 60-day limitation, may have a 30-day limitation, it may have a year limitation. It depends on what you bargained for with your insurance company and how that specific endorsement was written and how it affects your policy. So it's extremely important to make sure you get a complete copy of that policy. Exclusions. The point I want to make here with this slide is, as I read a few limited exclusions for you folks, you can understand just by the limited input that I put there that these exclusions are extremely difficult to understand. They're all over the policy. They have interactions with other parts of the policy, and it is extremely important to, we say, read them all, read them all, read them all again. And becoming familiar with your coverage is so critical. And how you can do that is you can talk to your agent, you can talk to your lawyer, you can talk to someone who understands this, but the best person to really talk to is a lawyer. And the reason I say that is most insurance agents don't want to make a decision on coverage. They want to write a policy and they want to service the policy as the best they can for their insureds. And their job really is to get the best coverage for their clients to make sure they understand the risk of their clients and properly match that risk with the best insurance policy. So you definitely should call your insurance agent to ask them to get you a copy of the policy, but I would ask a lawyer who deals every day kind of in the trenches, so to speak, with how these certain policy provisions come to life and how they may be applicable in real life situations. So just on this slide here, what I want to talk about is some of the different trends we're seeing. And this is not exhaustive. We're just kind of running our own little tracking the different industries and tracking how we're seeing policies and what endorsements we're seeing. Again, this is not exhaustive and this is not exclusive. We are seeing in certain industries, such as salons and restaurants, for some reason, there happens to be certain exclusions where the insurance company, such as the virus exclusion, where the insurance company may try to rely on. Other contingent business coverages, such as suppliers, such as medical providers, such as general office, we are not seeing those viruses. So medical providers, offices, retail, those types of industries, we are not seeing, doesn't mean there couldn't be, but we're not seeing those types of endorsements, and we're seeing broader types of all risk coverages. And that's just a general statement on the way we're, on what we're seeing related to specific industries. And I make this point very clear. Even if you see an exclusion that says virus exclusion, please make sure you have a professional review that to understand and determine if other provisions of that policy may apply. Because on its face, it looks like it's bad, doesn't mean there's another provision which gives you coverage back. The next part is I want to introduce Scott Rosso. Scott is our lead of property damage within the firm. He was a prior defense attorney with a very reputable, he was a partner at a very reputable defense firm, and he is one of our great attorneys in the firm, and he handles this in the trenches every single day. So Scott, if you would be kind enough to talk to us about some of the strategies our firm is using, as well as some of these legal strategies that are out there for the clients.
Absolutely, and thank you for the introduction, Marty. So there's essentially what we do is it's usually a 2-count complaint, but certainly we can, it depends on a case-by-case basis. We can certainly go with a deck action maybe and just go forward with that rather than doing a deck and a breach. But let me give you essentially what a deck action is, which is declaratory judgment. It's basically it's a legal determination of a court that resolves a legal uncertainty for the parties. So what does that mean? You've been hearing Marty talk a lot about this direct physical loss. So a lot of the issues that are going to arise with this whole, these cases dealing with this pandemic is going to be what defines the direct physical loss to the damage to the property, or does it need to be a direct physical loss? What is the direct physical loss? It depends on how the policy reads and how it's going to be interpreted, but certainly I'm seeing a lot of, my thought is it's going to be a deck action as well as a breach. And a deck action is basically it's a pleading that doesn't encompass the money damages. It's essentially just dealing with the legal ambiguities of the policy, if you may. So we want to always try to get our clients back to their pre-loss condition, and the way to do it is by these instruments, either a deck action by itself or a deck action and a breach of contract action. But it depends what the goals are in each case are, and you have to obviously look at the specifics of the fact pattern and the policy of itself to determine which angle we want to go with. But certainly that's something we'd have to look on a case-by-case basis. As far as bad faith, what that is seeking extra contractual damages, which means if the carrier didn't adjust the claim properly in the beginning, because what we do is we'll file a civil remedy notice early on in the case to put pressure on the insurance company to do the right thing, perhaps within the 60-day time period. And if not, then we'll go through the process, and potentially after the breach of contract or deck action cases are resolved positive to our client, then we can seek bad faith damages. So that would be a separate and apart case, but it's something certainly that to put pressure on the carrier to move the case along. As far as appraisal, Appraisal is something in the policy, which is certainly something that the carrier could certainly invoke, and potentially we can do that as well. What is that? It basically goes away from the deck action and the breach, which means it's not going to be in litigation. It means that it's basically an issue of damages. Appraisal is only going to talk about the covered damages. So if they do provide coverage, then it becomes more of a damages issue. Then it goes to appraisal. So they'll appraise the issues that are relating only to damages. So each side would get their own appraiser, and they would see if they could come to a common agreement between the two of them as to the amount of money that is owed to the client pursuant to the policy. And then thereafter, what they would do is then go to an umpire if they cannot agree. So from the umpire would need two signatures on that on the document to determine which way to, if it's agreed to or not, as far as the resolution of that case. So that would be binding. Appraisal is generally binding, which means that the case is over. So if they invoke appraisal, the case would end. So let's talk about bad faith in of itself. As I know we're talking to people that are outside the jurisdiction of Florida, so I wanted to talk to you about bad faith as a general term. So does the state where the policy issued have bad faith? So you have to look at your jurisdiction if it does or if it does not. Certainly Florida does under 624.1558, which is enumerated in one of the boxes here. You need to read the policy and the exclusions. You want to set up your case for bad faith in a way to make sure that the earlier you do everything, the more pressure you put on the carrier, which means they'll do the right thing in order to get to where you want to go. So, which is coverage and getting paid for the damages that you've encompassed to bring you back to your pre-loss condition. So you always want to make sure you comply with conditions precedent to the policy. We do that on every case. That's basically, you need to do that. If you don't, your case could get dismissed, which means if the insurance company asks for documents, you have to comply, you have to provide. If they ask for an examination under oath or something similar to that nature, a recorded statement, you have to comply. Otherwise, potentially they can dismiss your case. So you basically want to set up your case for bad faith. This way, to do the right things, to determine that, you got to follow basically these boxes, do the pre-loss conditions, and then potentially there could be extra contractual damages at the end of the matter.
Scott, would you also explain the civil remedy notice for us?
Okay, a civil remedy notice is basically a document that you provide to the department, and what it is you basically put them on notice, the insurance company on notice of the issues that they have failed to properly adjust. You could name the actual areas that they failed, you enumerate that, and then you put them on notice, and then they have 60 days to cure that. If not, they could be found in bad faith later on. You want me to keep going with that, or?
No, thank you, Scott. That was good.
Sure.
I was muted. I couldn't unmute myself. Thank you. Okay, now I'm going to take over from here. And I want to leave some time for questions, guys. So I'm going to end with this paycheck, the PPP, which we're all either hopefully trying to get or have received already, but the Paycheck Protection Program and how it relates to potential business interruption losses. The good news is that in Florida, we have the collateral source rule, and if an obligation, if a debt is required to be paid back, or there's an obligation that is required to be paid back, then Florida will not look at this as a set-off. And what that means is this: if you receive the paycheck, if you receive the PPP, Paycheck Protection Program, and you sign the promissory note, which you have to do if you take the loan, that creates an obligation to pay that loan back. Whether it's forgiven or not is a completely separate issue, but you still have an obligation to pay that back. So under the analysis, if you receive money from a business interruption loss and you have a Paycheck Protection Program, you receive that money, you will most likely not be required, if it's forgiven, to pay it back or reduce it by any insurance proceeds. So that's really important to understand. That is continually, by the way, changing. The SBA and the Treasury are issuing multiple updates on a daily basis, but I thought I would actually just talk about that for a second and how that relates to your business. Interesting, if you followed other states, and I'm going to hopefully open this up for some questions because I know there's going to be some, but I just wanted to highlight other jurisdictions: New York, Massachusetts, Ohio, New Jersey. These different jurisdictions, there are current bills today pending which would require an insurance company to pay business interruption losses even if there's an exclusion. This is a whole separate webinar we can do about the constitutionality of this and how this may affect you, but there are current jurisdictions where there are bills drafted, not laws yet, but they're trying to require the insurance company to pay these claims, even if there's a exclusion. Obviously, this is the information. Glenn, Jed, and Mary Shed, that's me, and Glenn we're the partners. If anyone has an issue, please call us. The numbers are here. Our local number, 561-995-1966. Our toll-free is there as well. We have a full dedicated intake staff. If you want to call the office, you can ask for Kelly McNeil as well. She's in our intake division. She'll be more than happy to provide you any questions. My email is mged@gedlawyers.com, mjed@jedlawyers.com. I also want to provide my cell phone. I have no problem with anyone reaching out to me directly. My cell phone number, 561-302-2518, and I'll be happy to answer any of your questions directly. And I want to open it up now for questions, concerns, comments, and Nick Gadian is going to be helping me field the questions and directing the traffic flow. Nick, if you can jump in here and answer or help the questions get facilitated.
Absolutely. Thank you, Marty. All right, our first question is from Michael Gordon. He's asking, does the claim exposure expire when the calendar changes to the next year?
No, well, it depends on the policy, but if your policy is renewed and you have a continuation of coverage, the answer would be no. But you have to look at the policy inception date and the policy expiration date, and obviously whether you renewed that policy or not. The coverage as it stands from the policy itself, there's a start date and an end date. So that is when the coverage is provided, unless, more importantly, you renew it.
Thank you. The next question is from Ken Huntman. Are you looking for individual clients or are you trying to start a class action?
Our model is we represent individual clients. We're really not a class action firm, and this is not set up, in my opinion at least, to represent the individual clients, because class actions, there's certain things that are similar to all claimants, and here the damages are completely different for every claimant. So I don't think a class affords the protections and really the right situation for the client. So I think these are going to be individual cases. And another reason for that is every single policy is different. In a class action, you have a common thread and a common claim, which ties those together to be adjudicated in a class. Here, I don't think that situation occurs.
Great. We have another question from Michael Beecher. When would mediation be used to resolve disputes between the insured and the carrier?
Great question, Michael. So in Florida, anytime you file a lawsuit, there's a requirement to go to mediation prior to actually going to a trial. Mediation is a great alternate dispute remedy. And in Florida, we are forced prior to going to court to actually a trial to sit down with the other party and a mediator who is an objective third party, either retired judge or attorney, to help you resolve the matter. But that happens usually at the end of the case when you've completed your discovery, you've had your pretrial motions, and everyone understands the risk and the reward of going to trial. And at that point, everyone understands the pros and cons of each other's cases.
Great. As of right now, we don't have any additional questions. We'll give it a few minutes and see if any more pop up. Marty, regarding when a client is required to pay the firm, can you kind of go over that with the audience a little bit?
Sure. We are handling these cases on a contingency fee basis. And that means clearly that if we don't recover any money for you, you don't owe us a fee. And our firm is obviously hiring the necessary experts to prosecute the case, hiring the necessary certified public accountants to put together the financials, and we will pay those expenses. And if we recover money, then there will be obviously a fee associated with that. And we work on a contingency.
Thank you, Marty. All right, Michael Beecher has another question. Is the decision of the mediator binding?
Well, the mediator doesn't make a decision. The parties make the decision in a mediation. So, for example, in a mediation setting, there's a plaintiff and a defendant, and then the mediator. And the mediator suggests to both parties certain things and provides information to both parties. However, the parties decide to resolve the matter. The mediator cannot resolve a case and cannot make a decision or adjudicate the case. He just paints the picture of the pros of your side, the weaknesses of your side, and does the same thing to the insurance company's lawyers. He'll tell them their pros, tell them their cons, and tell them why he thinks, in his opinion, you should settle this matter. Again, the parties make that decision.
But it would be binding after that point.
Yeah, yes, it would be binding. Thank you, Scott. It would be binding. The mediator would have you sign a settlement agreement right at that table, because everyone wants to know their exposure is over at that point and nothing else can be litigated. So there will be a settlement agreement drafted by the mediator at that meeting.
Awesome. Thank you, Marty and Scott. All right, and the next question is from Kenneth Tolchin. In your opinion, do most carriers try to do the right thing based on the policy terms?
Okay, I'm going to answer that a little differently. Insurance companies, by the nature of their business, are in the business to collect premiums and pay out as little as possible. That's the way they make money. That's the way their shareholders make money. It is our job as the plaintiff's attorney to actually demonstrate to them why they need to pay us. And a lot of times insurance companies do the right thing, and a lot of times they don't. So like any other industry people or actors involved in different industries, their job, again, by the nature of their business, it's inherent for them to collect premiums and not pay claims. That's how they make money for their shareholders. So it's our job to demonstrate and prove to them why they're wrong and get our clients paid. And we've successfully done that for over 25 years.
Thank you, Marty. The next question is from Linda Arcio. Do any specific actions related to a 501c3 apply?
I don't necessarily understand the question. You may want to clarify that for me, Linda, but if you're a 501c3 and you have coverage, I don't know of any reason why you can't be protected or why you can't make a claim. So I would say no to that. And if you further want to clarify, you can reach out to me or you can, use the chat box.
Thank you. And Marty, just for clarification, just because someone might have seen a virus exclusion from their policy, that does not mean that they will automatically not have business interruption coverage. Is that correct?
Absolutely, Nick. And I tried to express that in multiple different ways during the presentation. We need to look at the policy. We need to review that policy to determine if there's other provisions that may either override that or supplement that. So on its face, the answer is no. Have someone else review the policy for you.
Thank you. All right, guys, we still have a few more minutes.
And again, folks, one thing I want to highlight, we're in this unique situation with this pandemic. Everything we're doing, first of all, our office is fully remote right now. We have about 80 people in our organization. There are only minimum people coming in here to make sure, the mail flows, the checks flow, all that other, all technical stuff, but everyone's working remote. No one has to come to the office to sign up here. We're doing things in a DocuSign environment. We will absolutely protect everyone's health. We are not looking for you to come to the office if you have further questions. So no, you don't have to worry about that. We're doing this virtually.
Here's a good question, Marty. So the insurance companies pay our legal fees also, question mark?
Great question, actually. So depending on, first of all, there's a statute in Florida, which is a first party attorney's fee statute, and that's 627.428. And that statute reads, summarizing this really, that if you go to trial and get a final judgment, you are entitled to attorney's fees. Here, however, most 99.5% of cases don't go to trial, and we are successful in getting a portion of our attorney's fees paid for by the insurance carrier. So there is a high likelihood we're going to get a portion of your fees paid for by the insurance company.
If not all, if I may add.
Thank you, Scott.
We have time for one more question.
All right, great.
Sure.
Here's a last question from Luann Lindberg. Can you explain loss of market as related to policy language?
I don't understand the question. I'm sorry. Like the stock market, I'm not understanding the question. Could she clarify? Like market share or loss? I don't understand the question. Scott?
I didn't understand the question as well.
Talking about losing her business as whoever was purchasing her under
Builder's risk. Builder's risk. Okay, here we go. So builder's risk is, remember I talked about just a general insurance 101? A builder's risk policy, obviously you're building probably a house or a commercial building, and there's a builder's risk policy. I would need to look at that policy to determine how that comes into play. Based on the limited facts here, I'm really not comfortable answering it. But again, as I spoke before, there are all these different types of policies. This is another type of policy. So I would review that policy for you for no charge.
Awesome. Thank you so much, Marty, for that very informational presentation. We greatly appreciate it. As Marty stated, he shared all the contact information. So if you need to reach out to them or you have a question after this presentation, please feel free to touch base with any of them. And like they said, they'll be very happy to assist you. Thank you all for being here today. Thank you to the Jet Law Group for this presentation. Please be sure to check out the Chamber's website to look at any kind of COVID-19 updates that you may need. There's tons of links on our COVID-19 webpage. Also, check out our app. Make sure you download it so you can have all the information at your fingertips, events, updates, all those fun things, and give us your feedback. We'd love to know how we're doing, what we can do better. You know, your feedback is most important to us. And feel free to share any of our content. You can check out our YouTube playlist. You can share our events, upcoming events with your friends, colleagues. Even if they're not Chamber members, we want to help out everyone. So you can feel free to share that so that they can attend. And most importantly, please stay safe, stay healthy, and we will see you soon. Thank you. Bye-bye.
Thank you for having me.